having the opportunity here to say that one of the features of injustice that we've studied is the injustice of having Andrew Kull miss his lunch. He's always spent much more time on airplanes than any normal person ought to have to encounter. But we felt so good about the papers that we got that we wondered, well, how are we going to deploy these forces? And we wanted this session to be an informal session, a lot of questions, a lot of dialogue, whatever we get. If Andrew has thought about what to talk about, and he's going to do it. But this should be an open dialogue, and anybody can participate from whatever level they've got to start from. So, okay, Andrew, thanks for coming. Once again, Accolade, great achievement, and everybody's anxious to hear what you've got to say.
Well, thank you, Doug. Naturally, I'm pleased and flattered at the idea that a meeting like today's would have been organized. I'm delighted. As soon as I heard about it, I assured Doug Rendelman that, of course, I would, if something like this is going on, you know I will be there, as he said. I was surprised later on when I saw what I thought was the first draft of the program to say something about keynote address to be delivered by Professor Andrew Kull, because I thought I had said I would attend, but I wasn't going to open my mouth. Doug Rendelman reassured me, saying, all we need is to have you there and say something appropriate, but no one, of course, would want or expect anything substantive. So with that reassurance, I agreed to do this. Now, I thought about it, and I decided what I would talk to you about is something about the relatively recent history of the restatement of restitution, thinking about it in a broad sense. Basically, how did we get here from back there? I am indeed open to interruptions, I should say right now. Well, here's an interruption already. I was going to say I'm going to take the liberty of talking about events that in many cases I only surmised from what I have been able to see written down, and describe stages in this history for which I was not present. And there are some people here who were present, and I expect them to interrupt me and correct me when I misinterpret something. Do I see somebody, one of these people already?
I'm just trying to urge you to speak a little louder.
Oh. Sorry, I think I can do that. I assume this is contract class. I start this way. It is not difficult to find published statements by respected authorities, including some people in this room, to the effect that the original restatement of restitution, that's the 1937 restatement of restitution, created the modern law of restitution and unjust enrichment. Makes this area of the law extraordinarily recent discovery, and it makes it hands down the greatest achievement in the history of the American Law Institute. I think both of those facts, both of those propositions are essentially true, but it is an overstatement to say that the invention was, the discovery was in 1937. I've written elsewhere, I don't plan to repeat sort of historical demonstration. Where did the idea come from? How did they find it lying around the committee in the 1930s that decided to put it into the form of a restatement? I don't want to repeat what I said there, except to just point out one telling fact, it seems to me. The project that produced the 1937 Restatement of Restitution was officially launched by the Council of the American Law Institute in June 1933, and the work was finally approved at the annual meeting of the American Law Institute in May of 1936, which means 1 month less than 3 years from start to finish. By contrast, This project, our third restatement, had sort of a proto-advisors meeting in June of 1997. No one had yet been officially appointed an advisor. I was the reporter. Jeff Hazard, the director at the time, I believe wanted to make sure that his then untried reporter was presentable. And he was also holding a kind of a tryout for potential advisors, some of whom were not invited back. Approximately a year earlier, so June 1996, I had been invited to prepare a kind of a memorandum or prospectus. Would you be interested in being a reporter for a new restatement of restitution if we decided to do it? And if so, would you write us a memorandum giving a sort of idea of how would you approach this if we invited you to? And I did that. So, to the best of my recollection, the new restatement of restitution has been my principal extracurricular activity. It's fair to say for 15 years, conservatively estimated. Now, admittedly, the original reporters and advisors of the 1930s project were giants. The reporters, it's already been mentioned, Warren Seavey and Austin W. Scott of the Harvard Law School. Their advisors were, some of the names that people will recognize: Francis Boland from Penn, Edwin Patterson from Columbia, more people from Harvard, Thurman Griswold, Edward Thurston, Samuel Williston. It was very much a Harvard project. There were some other differences. As far as I can tell, the advisors in the 1930s would meet for 3 days at a time. They would also apparently meet every 2 or 3 months. Interestingly, they would meet not in a windowless conference room in Philadelphia, but at Bar Harbor. That's where William Draper Lewis had a summer house, or at the Homestead, or the Greenbrier, or the Cloister, depending on the season. They had stenographers who apparently took down every word and produced a transcript with multiple carbon copies. So they had these advantages. Even so, I would say it was done suspiciously quickly and could not have been cut out of the whole cloth. Of course, it wasn't. I say, to their credit, the somewhat more modest idea is that the great innovation in 1937 was that they took the legal side and the equitable side of the unjust enrichment law, which was already there, and put them together into one volume. This was a huge step because it went against the grain and against everybody's assumptions. And furthermore, it's due them to say it was not self-evident. I find it interesting, looking at the ALI minutes and reports, that in the 1920s, when they're talking about the organization of this new restatement, William Draper Lewis is up there saying, we're doing this, we're not starting on this. There was, at that point, he repeated several years, the trust restatement is going to reach at the end, chapter 10 or chapter 11 of the restatement of trust. It will, of course, be called constructive trusts. That's where it had been for the last 100 years or so, since they started writing treatises on trusts. It had always been the last chapter in the trust book. And we, when we get around to it, are going to have a restatement of the law of quasi-contract, which had also been around, since the 1890s. And so it wasn't obvious from the first day that, of course, those two things came together. One day, somebody at Bar Harbor said, why don't we fold these together? It would be so interesting to know who said that and just how did he put it. And it is one of the tiny footnotes of history that the whole set of carbon copy transcript of all of those meetings is no longer to be found in any of the libraries that at one point you might have thought would have it, and it seems did have it. It's lost, and so that moment cannot be identified. The first phase of Restatement of Restitution ends on really a fairly triumphant note, I would say, in 1937. The importance, usefulness was more broadly and more rapidly recognized and accepted. I would say less resistance than you might have expected if you didn't know. And yet everybody knows that within a generation thereafter, restitution in the United States went into a terrible decline. There's the ironic, notable contrast with its fate in the rest of the common law world. Anyway, people who have talked about why should this have happened in the United States do not generally say it was the fault of the Restatement of Restitution. I don't think it was. People talk about the general displacement of all private law subjects in American law schools in the 1960s. It was the point at which American law schools were turned into what John Langbine refers to as policy academies. To the extent that was happening, the course in restitution was among the first to go, basically on the principle of last hired, first fired. There was a related loss of interest among legal academics in legal doctrine generally. Lance this morning told us this wonderful anecdote about Austin W. Scott, talking about the requirements of an absolutely stellar career as a legal academic. You write a casebook, write a treatise, write a restatement. And think about that for just a moment. People who write about this say this is one of the after effects of legal realism. I dare say it is. There's no question that it's something that's happened. To the extent that scholarly attention has focused on private law subjects, scholars tend to focus on those topics that have a more obvious payoff, corporation law if we call it private, or at any rate that are amenable to a sort of policy-based instrumental analysis. What law, I suppose you could say. As my friend Ernie Weinrib said one day, many of you know him, a law professor in Toronto, he said, you know, the great thing about restitution, it is the private parts of the private law. I think I know what Ernie meant by this. Usually the only thing going on in a restitution case is can we figure out how to do justice between A and B? And if that is not enough of a payoff for you, you're not going to want to spend the time. Now, you might say, oh, who cares what's going on in the law school curriculum? I think part of the problem is that it turns out, on experience, that the law of restitution is a subject that a lawyer needs to have heard about in advance. You are at risk of missing it altogether if nobody has sensitized you to the possibility that this is something to look for and given you some idea where you might find it. I mean, think about it. By contrast, suppose you managed to get through law school. Suppose you managed to get through the first year of law school by cleverly arranging your schedule and not showing up. You never attended contract class or torts class, even passed the exam. Such things are possible. You will quickly hear about contract and tort law once you get into practice. People will point you in the direction of books that will fill you in. If it's a more specialized, more technical thing, if it's admiralty or bankruptcy, the same thing will happen. You probably never did hear about, you might not have heard about any law school, but you will not be lost for very long. Restitution doesn't work that way. And if you read the American judicial opinions of the last, I don't know what we should say, 40 years, I think you can see a general decline in the confidence with which restitution issues are argued and decided simply as the judges who went to law school, when they no longer were told about it, begin to ascend to the bench. I mean, you could plot it. That's what's happened. All of these historical factors, I think, doomed Restatement of Restitution to neglect, even if it had been more user-friendly. But in fact, it has some striking defects. Seavey and Scott put the law and equity pieces between the same covers, which was a great step. But if you wanted to be ungenerous, you could say that's all they did. They made no effort to integrate the two halves, which really looked as though they were separately prepared and then just bound together. The book presumes a reader for whom the law, the techniques, the language of law on the one side, equity on the other, are familiar, distinct, and recognizable. Although everyone thought, isn't that interesting, they choose to put these two things in the same volume. Nevertheless, this was the audience, and that's how the thing had been prepared. It therefore presumes a lot of technical knowledge that its readers were about to begin to forget. Doug Laycock, in a memorandum that he wrote in 1987, which has already been referred to, and I'm going to refer to it again in a minute, said the Restatement of Restitution was laden with references to the pre-1937 roots of restitution, references that became less and less familiar to the bar with each passing year. The federal rules doomed the restatement from its birth. By the time the American Law Institute was fully engaged in what it called the second restatement of the law, we heard about this already, the Restatement of Restitution looked older than its years. Almost before anybody mentioned that it was due for replacement, people were saying that it was overdue for replacement. I give you a few examples. After apparently a sleep of many years, the 1937 restatement was mentioned in 1970 at the annual meeting by Dean Prosser, as everyone called him, in the course of a discussion about contribution between joint tortfeasors. He's in the midst of restatement second of torts. And someone is saying, what do you plan to say about contribution between joint tortfeasors? Prosser says, oh, well, that's a restitution problem. Restatement of restitution allows it. Restatement of trusts, the first one doesn't say anything about it. He then says, now, assuming that some kind of revision is called for, the question is, where is it to be done? Should we assume priority and provide a section for torts to be followed by restitution, remembering that restitution is still a dream as far as the second restatement is concerned? It's 1970. No plans are yet made, as I understand it, as to when that restatement will be started. It might be 10 years. It might conceivably be longer. Restitution in 1976 comes before the annual meeting. Director Herbert Wexler told the meeting, I hope to see us get underway with work on the Restatement of Restitution, which is a big book that was published in the late 30s, but that will have to take its place in line. Wexler goes on to explain that the ALI has approximately $80,000 a year on which to run the whole restatement project. He says, the President and I have made efforts to supplement the endowment that supports that work, but thus far without success. Unfortunately, it does not involve sex or race or civil liberties and does not seem to produce much salivation on the part of Foundation executives. Restitution came up again in 1978 and in 1979, which was when Alan Farnsworth was presenting the concluding pieces of the second restatement of contracts. First year, Alan is in the middle of explaining an illustration in which an insurance policyholder submits a claim for total disability. The insurer, without investigating at all, sends a payment for partial disability. The policyholder signs a receipt that includes release of his claim. I acknowledge payment in full. Then the facts come to light. And the restatement of contracts is saying, in effect, that payment of the lesser amount by mistake is not going to count as consideration for the release. At this point, we have the following exchange. Mr. Paul W. Williams of New York. I don't think I know him. I would like to ask whether the debtor, he means the insurer, who paid the $500 thinking he was satisfying the debt of $1,000 can get his $500 back. Because many times it is done innocently. Professor Farnsworth. That is a tough one, and I always run to the Restatement of Restitution. There will be a Restatement of Restitution second, and it seems to me that is the appropriate occasion for that. Certainly anything that I would say in that regard, attendance of this illustration might be regarded as gratuitous if the reporter and advisors were to embark on such a project in the future. 1 year later, Donald Rapson was giving Alan Farnsworth a hard time about a case in which A makes an improper payment to B. Apparently, as far as I can tell, a payment that was not actually due under the contract between A and B. A makes a payment. C knowingly gets the benefit of that improper payment. Does not A have a right to restitution from C? I thought you were saying earlier that he did. Farnsworth replies, I don't remember saying that. Bratson. So you are saying that second restatement of contracts is not addressing claims against third parties? Professor Farnsworth. Yes. Most of the third parties' problems don't come up. You have to work to bring them in. If there is a restatement of restitution second, that is the place to deal with it. If there is not, it may be because of a feeling that these things are too hard to restate. The Institute was going to try anyway. The next phase of the story is not a happy one. In May of 1980, Herbert Wechsler announced that his colleague William Young of Columbia had been at work since February of that year on the basis of a document that was presented to the Council last May and that the Council liked. 5 years later, the annual meeting in 1985, Jeff Hazard's first annual report as ALI director included this note on current projects as follows. Restatement second of restitution. No submission on restitution will be considered at this meeting. Our agenda, particularly the corporate governance and foreign relations law projects, are already very heavy. In light of this constraint, it became useful to afford Professor William F. Young, the reporter for restitution, an extended period of concentration on analysis and drafting. We expect to have more from this project next year. There was no more. Disregarding the time that he must have spent preparing an initial response to Herbert Wechsler's solicitation, Professor Young had been working on second restatement of restitution for 5 solid years. Those 5 years must have been as frustrating an experience as any ALI reporter has ever had. Many of you know Bill Young, and anyone involved in our restatement third who did not know him already got to know him as a result of Lance Liebman's single most intelligent contribution to the project, namely his idea to ask Bill Young if he would be interested to join the group as an advisor. All of us came to admire his imaginative intelligence, his extensive knowledge of restitution and related fields, his unfailing gentleness of expression and graciousness of spirit. Those last 2 qualities, I think, may have served him better in the role of advisor than in that of reporter. The careful written comments I received from Bill Young on each successive draft were among the most reliably helpful I did receive, and there are numerous points in which third restatement of restitution has been improved as a direct result of his suggestions. So his ability and intelligence are beyond question, but the second restatement of restitution went very badly. Some of the problems, in hindsight, must be ascribed to misjudgments on the part of the reporter. I do not mean to dwell on the problems he encountered, and an elaborate post-mortem would certainly be beside the point, but I want to give you the flavor. The project began under an ill omen. An all-star committee of advisors had been appointed. It included at the outset John Dawson, Alan Farnsworth, Dan Dobbs, Ellen Peters, Michael Traynor, John Wade, Charles Allen Wright, and John Frank, famous Yale law professor who by this point was practicing law in Phoenix. 3 days before the first meeting of advisors, this is June 1981, Frank wrote to Young to express his regrets that he would not be able to come to Philadelphia. Instead, he was forwarding a memo setting forth criticisms of preliminary draft number 1, the very first, which had been compiled by Frank with the help of half a dozen summer associates at Lewis and Roca, whom Frank had assigned to review preliminary draft number 1. The draft, by my calculation, had only been sent out 2 weeks earlier. Frank's letter with its memo, its attachments, uniformly critical, was 53 pages long. Mike Traynor presumably attended this first meeting of the advisors.
Almost certainly.
And he could perhaps remember it and tell us. I can tell you that preliminary draft number 1 became council draft number 1. It was submitted to the council in the fall of 1981. Council thought more work was needed. A revised draft was presented to the advisors the following September. It's now 82. Dawson had resigned from the committee. I don't know why. He wasn't there anymore. It was presented to the council 2 weeks later, and we eventually had tentative draft number 1 at the annual meeting in 1983. The proceedings of that meeting are very painful to read, and for anyone who's been an ALI reporter, they are really a nightmare. The first afternoon bogged down in the discussion of section 6 sub 2. This was scarcely a quarter of the way into a fairly short tentative draft. And this provision, it's interesting, this morning we heard somebody make a favorable, a wistful reference to it. Was that you, Peter Linzer? This was a draft in which Young had, I think, incautiously said, or was it Mike Traynor? A party might be unjustly enriched if his conduct, I'm quoting, in negotiating for a gain or advantage appears unconscionable in purpose or effect. So it's kind of combination with pre-contractual liability with an unconscionability idea and this purpose or effect. The looseness of this last expression brought forth a torrent of objections. If the meeting had been chaired by a surer hand, or one more solicitous of the reporter, and I definitely mean somebody more like Lance Liebman, it should have been easy to conclude that this section needed work and to set it aside after, perhaps 10 minutes at the most. Instead, the chair allowed the contentious discussion of this provision to drag on for at least an hour, I think possibly an hour and a half. The atmosphere was now thoroughly poisoned, and the remaining discussion was dominated by motions to redraft this and recommit that. When Restatement Second came before the annual meeting a year later, in May of 1984.
Who was the chair?
I think it was Perkins. I think. Tentative draft, the project fared no better. Tentative draft number 2 began, I think very unwisely, with a chapter on constructive trust, equitable lien, subrogation, and marshalling of assets. Those of you who know why I think this isn't what you want to be doing. Those of you who don't, I would just say these are most difficult parts of the subject, or close to it. Almost immediately, the reporter was confronted by a pre-arranged motion submitted by John Frank and Robert McCrate, both of them council members, directing the reporter to replace the word subrogation throughout the entire draft with the word substitution. This led to a spirited debate, and the motion was very easily defeated in a voice vote, but that victory would prove to be the high point of the day. No more than halfway through, discussing a difficult section entitled Apportionment of Gain from Proceeds and Products, Mr. Laycock was finding the draft troubling and moving to strike certain language. Others were moving to substitute their own editorial suggestions for the language of the reporter. John Wade was urging that the entire tentative draft be sent back to committee. Motions from the floor led to more motions from the floor, and the meeting concluded with the project in disarray. There was another council draft with recommitted sections that December. A final preliminary draft was prepared and circulated for an advisors meeting that was supposed to be taking place at the end of January, beginning of February in 1985. It was after this that the reporter was afforded, as we have seen Jeff Hazard describe it, an extended period of concentration on analysis and drafting. Restatement Second would have been a difficult job in any event. It seems to me that Professor Young made at least 2 major errors that tipped the balance against success of the project. First, he properly felt that he had freedom to innovate, and he certainly indulged that freedom. He nevertheless seems to have conceived the task before him as one of revising and improving the 1937 restatement, starting with the recognized difficulties. So, tentative draft number 2, for example, presented the membership, which had scarcely recovered from the shock of the previous year's discussion, with topics of constructive trust, subrogation, and tracing rules. In short, I think Professor Young failed to recognize that a new restatement of restitution had to start on an entirely clean slate and be written for people who knew no more about restitutionary claims and remedies than do reasonably bright first-year law students. 2, he neglected an elementary strategic consideration, which is, to my mind, that he had to start with what was easiest to understand and hardest to argue with, building confidence among his advisors and counsel and membership before tackling the more difficult parts of the subject. By the time our project reached the topics of constructive trust, equitable lien, subrogation, and tracing through a commingled fund, the ALI annual meeting, I don't say the advisors, but the annual meeting, would have approved anything we said because they were no longer paying attention. Now, the genesis of the third restatement, what we have now just finished, is to be found in one document. It's beyond question. The third restatement starts in Doug Laycock's memo. It's entitled Report to the Director of the ALI, preliminary report on a restatement second of restitution. We're still trying to get past that. Doug wrote this at the request of Jeff Hazard, who had asked him, quoting, to consider whether there is a coherent subject that is worth restating, and if so, the desirable contents of such a restatement. Laycock's report, dated November 1987, answered the two questions in two parts. The first part addressed the parochial problem facing the ALI, which was whether to try again with a restatement of restitution. The longer second part of the memo proposed a practical summary of what the law of restitution covered and why it mattered. The second part was revised and published as an article in the Texas Law Review in 1987 under the title, The Scope and Significance of Restitution. And in that form, I expect many of you have read it. I recommend it. The first part was not published, and so far as I know, is not generally available. But if anyone is interested in the history of why our project took the form it did, the place to find the answer is the first part of Doug's memo. His summary of conclusions at that point included the following points. I've abbreviated slightly. He says, restitution is a distinct body of law amenable to restatement. The defining characteristics of restitution are disputed and its boundaries are amorphous, but there is practical consensus on the core contents of the field. Restitution is of practical significance when it adds to the other sources of civil liability. Much of restitution is practically significant in this sense, but not all of it. Restitution is not systematically taught in the law schools, and it is not litigated frequently enough to create a fully developed body of precedent in each jurisdiction. Because the law is unfamiliar and undeveloped, a restatement second could have unusual influence. A good restatement might be especially valuable, a bad one might be especially harmful. Because lawyers are generally unfamiliar with restitution, it is especially important that a restatement second be clearly organized and written. The unfamiliar language in which restitution arose, such as quasi-contract, should be avoided as much as possible. It is possible that the decline of professional attention to restitution is irreversible and that a restatement second would have little impact. The greatest difficulty in restating restitution is identifying a reporter. Few, if any, scholars are comfortable with the entire field. Short of offering to be the reporter himself, Doug's endorsement of the project could hardly have been stronger. But Jeff Hazard was seemingly unwilling to take yes for an answer. He commissioned another report from another law professor, this time from Dale Osterly, then of Cornell University. Dale Osterly had published a very well-known article in the mid-1980s attacking the tracing rules as arbitrary and irrational, thereby joining the Jim Rogers faction. Jeff Hazard's annual report for 1989, so this is 2 years after Laycock, advises the membership that the Institute is pursuing a restart of the restatement second of restitution. He mentions what happened. The previous drafts ran into trouble. We have had a further examination. One study has been completed. You know, that's the Laycock memo. Another is well along that these give promise of supplying the necessary conceptual framework for this subject. Now, Osterly's promise study, which was dated June of 1989, arrived a few weeks later. On the question of what the ALI should be doing about restitution, his conclusions were almost the opposite of Laycock's. In answer to the question whether restitution is an appropriate subject for a separate restitution restatement, Osterly concludes that it is not. Either restitution principles should be included in each of the restatements of contracts, torts, agency, and property law, or it should be included in a new restatement of the law of remedies. It was the Osterly memo, not the earlier Laycock memo, that Hazard found persuasive on this central point. Addressing the annual meeting a year later, he announced a change of direction. He says, "We are exploring a restatement of remedies. This is a sort of daughter of restitution. We had begun restitution some years back, had some difficulties with it, and reconsidered those difficulties. A restatement of remedies would be even more complicated and challenging, but perhaps more coherent in the end. We are aware that the dimensions of this subject could approximate Godzilla." A year later, he repeated, "We contemplate a restatement of remedies building on work begun in restitution." This was 1991. The Institute's deliberations now moved off stage for something over 3 years. They reemerged in January 1995 when the AALS section on remedies held a well-attended program at its annual meeting devoted to the question, can and should the law of remedies be restated, and if so, how? Some of you were doubtless present that day. You may recall the meeting that year was in New Orleans. The chair of the remedies section and the moderator of the section program was Douglas Laycock. And Douglas Laycock had almost certainly prepared the list of questions announced for discussion, some of which read as follows. Does anyone want a restatement of remedies? What would be its benefits? Would they be worth the cost? Would the project be manageable, or is remedies too all-inclusive to be restated? Is there a core of people willing to do the work? If there is to be a restatement of remedies, how should it be organized? Should there be a restatement of trans-substantive remedial principles and also of remedies for particular wrongs? If only one of these, which one? Announced speakers, in addition to the moderator, were Alan Farnsworth, Mary Kay Kane, and Tom Rowe, all of whom were invited to discuss the treatment of remedies in various ALI projects in which they had been involved. Also Dale Osterly, identified as respondent. My own recollection of the session is that there was a lively discussion of the pros and cons of various ways to have a restatement of remedies, and that no one in the room expressed any regret, any acknowledgement of or regret for the fact that proceeding in this direction would clearly imply abandoning restatement of restitution and abandoning the central contention that restitution is a basis of liability and not merely an alternative remedy for liabilities found elsewhere. That is, until I stood up and said something to this effect myself, my recollection is also that my remarks in that group were received with a general air of, how did he get in here? I may be wrong, but the idea of a restatement of remedies was very readily accepted by the people present on that occasion. In retrospect, I think I can guess what was happening to this project between 1990 and 1995. My surmise is that Jeff Hazard was attracted by Dale Osterly's suggestion that the ALI forget about restitution and prepare a restatement of remedies, and that starting about 1990, he must have been trying to persuade Doug Laycock to take the project on. The questions proposed for discussion by the remedies section were so neatly formulated because they were the questions that Doug Laycock had been asking himself for several years. I know that Laycock was thinking seriously about doing it because before we left New Orleans, he asked Doug Rendelman and me to have lunch with him and said if he agreed to do a restatement of remedies, which he said was by no means certain, would we be interested in serving as associate reporters, Rendelman for injunctions, Kull for restitution? My recollection is that Rendelman said yes, and that Kull said yes, but for whatever reason. And I don't know. The lasting effect of that AALS meeting appears to have been that Doug Laycock was persuaded to refuse the job of reporter for a restatement of remedies. Jeff Hazard, a few months later, told the ALI, "We have continued interest in a project for a restatement of remedies, or perhaps a revisiting of the restatement of restitution." A remedies project obviously would be wider in scope and correspondingly more formidable than one on restitution. We had in mind a candidate for reporter, but that opportunity has alas disappeared. We are open to suggestions. I have no idea what happened over the next 12 months. But the 1996 report of the director has Hazard's statement that, "I have talked to you several times about remedies. It turns out, I think, that we might be well advised to redefine the project back to the subject of restitution from which remedies originally sprang in the mind of the director." And a week or 10 days after that year's annual meeting, I received a letter from Jeff asking whether I would be interested in serving as reporter for a new restatement of restitution should the ALI decide to undertake one. If so, they would like me to prepare a memorandum explaining how I would go about it. But this is where we came in.